Well, it's 11 o'clock here in Vancouver, and I think we'll get started. Maybe some people will join us, but thanks for joining. My name is Geeta Keshava, and I'm a litigator at Bennett Jones in Vancouver. Today is part one of SABA's 5-part series on trial, tribunal, and appellate advocacy. For those of you who joined us last year at the beginning, quote unquote, of the pandemic, welcome back. We hope this offers different perspectives on trial, tribunal, and appellate advocacy. For those of you who didn't get to join, well, here's your opportunity. We hope you enjoy. We are joined by 3 panelists today to discuss pretrial matters, opening statements, and direct evidence. These 3 panelists are civil litigators and are Erica Carrasco, Arif Chowdhury, and Amandeep Dhillon. By way of brief introduction, so we can get started, Erica is a partner at Field Law in Calgary. She has a background in insurance and construction litigation and has a broad practice covering corporate commercial matters, property and commercial liability, product liability, builder's risk, motor vehicle claims, builder's liens, as well as a particular interest in emerging technology law. Arif is a partner at Fasken in Calgary. He too has a broad commercial litigation practice covering labor and employment, privacy, technology, fraud, product liability, class actions, and insolvency and restructuring proceedings. And last but certainly not least, Amandeep is counsel at Creamer Siman Dhillon LLP in Toronto. He has a corporate commercial litigation practice, also covering a broad range of contract disputes, shareholder and partnership disputes, oppression matters, negligence, construction, real estate litigation, and civil and commercial fraud. We're going to start off today with Erica, who will discuss pretrial preparation, and then Arif will discuss opening statements, and last, Amandeep will discuss direct examination. By way of housekeeping, I will be keeping track of the chat, so please post questions as we go along, and hopefully we can answer time permitting between the presentations. Erica, with that, I'll pass it off to you to get started with pretrial preparation.
Hi, everyone. I am hopefully able to move through my slides. Let me just do a little check here. That's interesting. I don't actually know how to change my slides on the share screen. Maybe, Geeta, do you know how to do that?
You should be able to just...
I see how. Haha.
Yeah, perfect.
Me.
Fantastic.
See, learning every day. Well, thank you for the kind introduction, Geeta. As mentioned, I'm a partner here at Field Law in Calgary. I practice in commercial and civil litigation, and I'm the head of the emerging technology group here at the firm. And so I've taken a slightly different approach to preparing for a trial than I think my friend Andy Hayer did last year. And I've gone a little bit further back from the beginning of the file. And the reason that I've done that is based on my experience. These are some of the things that I wish I had this top 10 checklist when I first ran some of my own trials in the beginning. And now I find it particularly useful, not only to relieve stress right at the nth hour of trial, but really to understand the strategy and options available as I move forward in the litigation and the strengths and weaknesses of my case. I also find this checklist really helpful for client management and budgeting for the client so that they're not faced with a high amount of cost or trial preparation fees right at the end of when we're preparing for trial. And they also understand why it's important for you as their lawyer to be prepared and to understand all of the facts about their case early on. So I also, realize that there's a practical matter to this. And so I will leave this top 10 checklist with you to decide how it will work best for you and to employ it in the most cost-effective manner for your client. Also, just with that in mind, to make sure that when you discuss with your client these various options and strategies moving forward, that you paper your file to make sure where your clients don't want you to take certain steps in the analysis or prepare in a certain way, that you've made that very clear that that's their choice in doing so. So here is the top 10 list. And why I call it the top 10 list is it's sort of the different milestones or categories which you might want to turn your mind to preparing for trial. And you'll see that we're starting right from the beginning at gathering and preserving facts and evidence. And some of this may seem like a no-brainer to you, so bear with me and take what you can get from this presentation, but it's all based on your own experience. So hopefully you can take some tidbits from this and tailor it to suit your files. Why I put this right up front is because I think that when we get busy or when we focus on attracting and retaining our clients, we are looking at what is the particular problem that they want us to solve, which is great. But oftentimes clients come to us and they say, okay, for example, I want to sue this party. So, let's prepare the statement of claim and get going. Or someone comes up, I've been sued. I need you to file a defense or we're going to be noted in default. And our mind suddenly just starts to focus on the immediate task. What this number one checklist is supposed to help you remind yourself is, yes, there's an ultimate task. Yes, there might be a time sensitive step, but shortly thereafter, or if you can before, you really need to make sure you have the big picture. So I think we all remember in law school when we took some trial advocacy courses, we talk about that T funneling technique. This is exactly the time that you want to try and remind yourself of those old principles. Start with this really big basket of the big picture, who your client is, how they came to be in this circumstance, what was the background information leading up to this step, and then try and go through some of the systems or steps that what happened that where there might have been document or data creation. So those are the things that in your mind you're trying to gather facts, information about witnesses, and information about where documents, evidence, or data might be stored. And obviously in this day and age, it's not just a paper file we're thinking about. We're thinking of the preservation of a multitude of different electronic sources, including their own computer systems, their own personal and corporate mobile devices, as well as maybe places where they're posting on VPNs or social media. So you really want to try and go as broad as possible to at least compile a list of these things, and then you at least have that to go from. Part of this exercise is also to help you identify keywords, dates, and names of people that you want to keep track of. And so one of the examples that I have of this is sometimes, well, we all know that trial can take years to come to fruition. And when we're dealing with certain individuals who might have been the author of key documents or who might hold key information about the particular instance, you're going to want to make sure you preserve their evidence in some way, shape, or form. I guess the example that I have there is you could have a case where someone starts off as an agreeable witness and they support your client's claim and have good things to say about what occurred. But as the matter progresses, they could become more and more hostile, or maybe their relationship with the client changes. So the best that you can to preserve the evidence of the individuals closest to the time at which this occurred, you can either do that by way of having that individual write their statement and sign it. You can consider getting a third-party investigator to take that statement, or you can consider whether you need to go as far as a statutory declaration or some form of sworn affidavit. So all of that is just going to depend upon your relationship to that individual and keeping in mind what you might want to use that statement for in the future. If you just get them to write something down and sign it, that's usually something that can be helpful for a witness who you just want to be able to refresh their memory at trial. You might want to get something more formal from a third party signed so that they can be called at trial to say they took that statement and that's the truth. at least to some extent if the witness dies or something like that. But you might also want to use it later if you think the witness will become hostile, to either impeach them and put a prior inconsistent statement to them. So those are some considerations you might want to think about, at least at the outset. And you also want to think about doing this because you don't want your client to be accused of spoliation, and you want to make sure that you have safeguarded any kinds of original documentation. Also, when making your witness list, just make sure that you keep track of contact information for the witnesses so that you can frequently update it or touch base with the witnesses as time passes so that you don't lose track of them. So that's sort of the importance of this initial phase. And of course, things are going to evolve as you go, but if you can start by start keeping list of key documents or places where documents are found, key individuals, keywords, dates, and names, then you can start building from that. So then the next step, theoretically, logically, if you can and you have the time, is to try and start developing the theory of the case and whether you're going to need or want to use an independent expert to assist you. Now you might think that's crazy. Why would you engage an expert this early on? But I can tell you that in two cases, one where I engaged an expert sort of in the normal course, if you'll have that, which is maybe after questioning and you are getting closer to trial, versus right from the outset, really made a big difference in how I was able to develop the strategy of the case and prepare for the next steps going forward. And I'll talk about that a little bit more. But what it means to develop the theory of the case is really understanding what causes of action and what theories of law are at play. And so oftentimes what I'll just do is a very basic, some very basic legal research, which may not actually be research. It may just simply be locating what you know to be the key Supreme Court of Canada decision that outlines the test, or a seminal Alberta Court of Appeal or your Court of Appeals jurisdiction that outlines a test, so that you're very clear on what elements of the case you're trying to prove. You know what you need to note up periodically in order to see if there's been any changes to the law. And you can, again, keep a checklist of what it is that you're trying to do with respect to your strategy. And so why you want an expert early on is basically because while you're developing your theory of the case legally, there may be aspects technically that you're not aware of. So when we talked about the preservation of evidence and witnesses, being able to engage an expert about what you're trying to get their opinion on will help them tell you, okay, well, I'm going to need to see documents that look like this. There's going to be an individual who is in charge of this that likely has certain information we're going to require. And so they'll help you shape that theory of your case. Another reason why you want to at least retain an expert early on is because if you're going to run into a situation where other parties are also retaining similar experts, you don't want to be the last party to retain an expert and not be able to find someone, in your jurisdiction, not be able to find someone in Canada, maybe have to go to the US. It makes things a lot more tricky if your expert's not accessible and not cheap, which that happens as you go outside of your jurisdiction. And if your client, thinks, oh, this is a really big expense to be taking on so early, I think that you can easily explain to them how this helps save costs later on. One of the examples that I give my clients is that you'd rather know earlier rather than later whether the expert can give you the opinion that you're hoping they can, how costly it will be to engage in the steps that they'll need to form that opinion. And having them there every step of the way will actually ensure that the opinion they give you once is the right and final opinion, instead of having addendums or other kinds of things to their reports, which can have an impact on the weight that it's given. So another reason why is if you wait until closer to trial to retain your expert and then they can't give you the opinion that you were hoping, now your client has spent a lot of money up front to be told that maybe the strength of their case isn't as good as we'd hoped. So I do think that while it is a bigger spend up front for the client, it really does help in client management, and it helps in strategizing whether you should settle or not at different junctures along the way instead of on the eve of trial. So the example that I was going to just give you about an expert engaged early versus an expert engaged late was also dovetails later with other headings that I'll speak to. But in one case, the expert was retained in the normal course closer to the time of trial. And it wasn't until that time that we realized that certain parties had not been named in the action that likely had information and were liable, and that there was a piece of a piece of a pipe that was actually missing. That was the key piece for a causation analysis. And none of the other experts had actually clued in on it. But the experts all agreed that without that piece, they couldn't make any definitive causation finding. And so in a way, it was helpful for our client, who was the defendant, because the plaintiff wasn't going to be able to prove on a balance of probabilities what caused the incident. But we had all spent thousands of dollars on expert evidence that really led nowhere. And then that same expert, after learning from that, I retained them early on. And they were actually able, before we even got to production, to give us a list of documents that we should expect to see from the particular parties in the claim. And also when they weren't seen in the production, we were then able to compel them. But they also spent time with us to help us devise the questions for questioning and help explain the technical questions that we could put to the witness. And so that really gave us a lot more confidence that what we were doing at questioning had meaning for the strategy and had meaning for our expert. And you know, that wasn't very costly. What it required was about an hour conversation with the expert, and to just go over what we needed, an hour of them reviewing the list of production, and then another hour to help us devise questions for questioning. So it can be very streamlined. So the other area is pleadings and amendments. And again, so when you're filing your pleadings, this is where the theory of your case is critical. So you can plead the proper causes of actions or defense. Knowing the rules of court is also critical. And so I would encourage you to be familiar with the rules of court of your jurisdiction on an ongoing basis. If you're going to prepare for trial, you're going to want to know all of the ways that you can use the tools from the rules of court to help you narrow that. You also obviously need to be aware of where you need to plead particulars, where you need to plead statutory defenses, and again, this comes back to keeping that checklist of the theory of your case and the elements to prove it, because as that theory changes, you're going to look to your pleadings and see, do you need to make amendments? And while we can often make amendments up to the eve of trial, the amendment or the pleadings themselves are part of the theory of your case. And so as you're producing documents, as you're going through questioning, that shapes what's relevant and material. And so if you wait, or a party waits to amend their pleadings much later on, then you may not have gathered the necessary information, production, or evidence through questioning that you need to disprove those amendments or prove your claim. And it can make the litigation much more complex to wait till the last minute. You also want to be mindful, obviously, of the limitation period that might be applicable to amendments, and ensure that if you're going to name ABC corporations or John Doe's, Jane Doe's, that you've properly identified them in the pleading so that you can replace them with the entity name. And I would also encourage you that if there are any parties you think might be involved in the litigation, to put those parties on notice of a possible claim against them early on. That way, maybe Section 6 of the Limitation Act will save you if you are technically out of time. So the real life example that I can give of this is where we were retained to defend a party in a pleading where they weren't properly named. We thought they were sufficiently named that it identified our client. We went ahead and defended on that instruction, only to find out there was multiple other entities with very similar names that could have been that entity, that likely it wasn't our client, that was the party that was named. And then we became stuck in this lawsuit, and we're here 7 years later trying to figure out who the proper parties are, Whereas if we'd simply ask the plaintiff to clarify or to amend their pleadings or properly define the parties before we defended, it is likely that our client in its version of one of the 10 entities wouldn't have been named. So, you know, it really does have an impact on how things proceed and progress. So moving on to production and privilege records, and I know I'm going very fast through all of these, but hopefully, again, there's some helpful information here. When you are going through your producible documents for your own clients, you're again going to go back to your theory of the case and why they're relevant and material to proving your cause of action, or on the corollary to defending a particular cause of action. One of the things that I learned in reviewing documents is when I prepared my summary, I used to simply prepare it based on the date of the document, who produced the document, and what key information was in the document. At one point, I had a summary of thousands and thousands of pages of multiple parties of their documents, and thought I had this really wonderful summary of these documents. We were getting ready for trial, and we were served with various witness lists, including lists of witnesses that the parties weren't intending to call. And when I went through our records, I couldn't identify who any of the individuals were. So what I realized was these were the names of particular authors of different pieces of documents, which they weren't intending to call, excuse me. And I had to go back through every single record to try and find who these individuals were, to see if I agreed with them not calling these witnesses or whether we needed to call them to authenticate the documents. So it's really important that when you are gathering and summarizing production at an early stage, you think about how those documents are going to be used at trial, and you record the appropriate information, such as the actual date of creation, whether it's an original, whether or not you know who the author of the document is, so that you can then determine, do you need a different document? Do you need to call the person at trial, and start keeping track of that information? The other thing is when we get parties' affidavits of records, we often don't necessarily look at their privilege records, or they're just very generally described. They should be described sufficiently that you should be able to glean if there's something that you might want to compel to produce. So statements or reports from experts, at some stage, they may become relevant and producible. And so you'll want to take a look at those early on. I also recommend that it be your practice to review the affidavit of records of other parties with your client to see if they can identify places where documents are missing, and to compel a complete and affidavit of records long before questioning. We often wait until questioning to ask for those documents by way of undertaking as a less costly step. But what I found is it makes the litigation more iterative, and then you have to question again on those documents. So it sometimes makes sense, if you can, to take the time to compel those records up front and see if you can get them that way. Obviously, when I say compel, when you're dealing with cooperative counsel, you can make those requests without a threat of an application. But if you're dealing with a contentious matter or with a self-represented litigant, you're going to want to consider compelling and applications right away. And of course, as you go through the records, make sure you update your witness list. So then moving to questioning and read-ins, this again comes back to doing your questioning with a view of read-ins and a view of what you're going to be using at trial, and using your expert's knowledge to ask the right questions, and considering what new areas of information are arising, and that's where you ask for the undertakings. Another thing you might want to consider is before questioning, if you're at a point where there's enough facts that should be in agreement, you can serve a notice to admit. I found that in certain cases, serving that notice to admit in advance of questioning helped narrow the issues that we needed to question about, especially when you're talking about an application for summary judgment. If you're talking about questioning on an affidavit, sometimes serving a notice to admit in advance of that is helpful. And I would also consider serving a notice to admit at some point in advance of trial if you can't come to an agreed statement of facts, or you don't think that that will be the case. Another tip that might be appropriate is to explain to your client the cost of transcripts. I think it's useful for you to review the transcript from your clients or the other side's questioning almost shortly after questioning, so that you can see if there were any areas of questioning that you missed, if there's a good read-ins, or if there's places where you're still missing information. And if there's any errors, because that you'll need to correct those errors by way of affidavit with the court reporter if they're actual errors in your client's evidence, or if they're just typos to get the court reporter to change those. You don't want to be waiting till the transcripts are filed with the court to be telling them that there's issues with them. All right, so moving along to preparing witnesses. This comes back to your witness list and the contact information for each witness. You're going to want to also make sure that you're staying in contact with your witnesses on a regular basis, or they can easily disappear. And again, you're going to want to have some tools and things to help them refresh their memory from time to time, especially before trial. One of the examples that I had was related to the read-ins, where I had taken over a file that was from 2004. It was going to trial in 2017. When I got the file, it was basically to prepare for trial. And so I was very focused on matters for trial, the immediate matters for trial. I was at the last minute going back, reviewing transcripts for read-ins, and then preparing the witness who I thought, all they're going to do is say what happened. Well, it turns out that when I ended up preparing the witness a couple of weeks before trial, we discovered that they needed an interpreter. We weren't able to get an interpreter until the eve of trial, and there was a really, really bad matchup between our witness and the interpreter. There was credibility issues for trial, and ultimately we didn't succeed at trial. There was a mixed success, but I think a lot of it had to do with the fact that we weren't prepared with our interpreter long before the trial, and our witness was not prepared with an interpreter and didn't know how to give evidence through the interpreter because they'd been giving it in broken English up to that time. So making sure that your witnesses don't need special things like an interpreter or any other requests that they might have to make them comfortable is really important. And really remembering that those witnesses have never been through the process for the most part, and that especially now in this remote day and age, we need to walk them through how it's going to be and make sure they understand how critical it is for them to give clear and proper evidence. You'll hear more about direct and cross from the next two speakers, so I won't go into too much detail about preparing them specifically, but you really want to explain every facet of what could occur at trial, last minute changes, get them prepared for that kind of thing, questions from the judges. And then coming to closer to trial, this is where we're talking about getting your agreed statement of facts and exhibit books together. It's really important that you show that you've made every effort to come to court prepared. And so remember when we were talking about that T funnel, if everything's working as planned, you've now taken all of this information from your client and you've really narrowed it into the story and theory of your case. And so you can now have that opportunity to shape this agreed statement of facts to make sure it mirrors that and propose it to the other side, put together an agreed book of exhibits. One of the biggest things that I've learned over the course of my practice is you can have an agreed book of exhibits on a different set of bases. So you can have a set of records that's going in for the truth of their content, another set of records that's going in as business records, another set of records that you're admitting, but you're not agreeing to any opinions stated in those records, and just records that still need to be proven at trial, that both parties agree will be proven at trial at some point, but they're not agreeing that they are already proven, if that makes any sense. So you can consider your exhibit book to be set out in different sections that way, but it helps the judge then have an agreed book to go through. You can all refer to the same tabs, and it's still helpful even though there hasn't been a complete agreement on all areas. And so the next place as you get closer to trial, Hopefully through the course of your file, you've been reading up on rules of evidence, the rules of court, and are getting familiar with the types of objections that you might be making. And this is where you can then start to create your cheat sheets. So cheat sheet of objections so that you can easily stand up and object with the proper description, know the rules of court and what you can allow or not allow, or what applications you can make at different junctures, know what particular laws of evidence or tests will be applicable if you want to impeach a witness or attack their credibility. If you need to put an alternate version to the witness, have those like little reminders ready and organized. I have a little binder with all the key case law of what I need to follow in order to do these kinds of things, make adverse inferences or argue them, so that I'm prepared. And I have another list of objections ready. And I also have different binders prepared per witness that has, you know, the questions for the witnesses, what I need to get from each witness, as well as the documents that I want to put to them. And so that starts to get into the preparation and setup itself. So that's where you need to really say, how do I want to organize myself? Lots of us are now electronic and everything is set up electronically, especially for remote trials. But you also want to figure out, do you have a backup for that? If something fails, do you want to send hard copies to the court just in case? Do you want to have hard copies for yourself and for the witnesses just in case? Again, this is really about relieving everyone's stress and anxiety during the trial, making everyone comfortable and making it easy to follow along, especially for you and the judge. So those are the people, yourself, your witnesses, and the judge that you want to make sure feel the preparedness, feel the comfort. And if you're not prepared and you're not stress-free, you're not going to be able to impart that on other people. So part of being organized is taking all those steps that I just described and then having a system that works for you, and then reminding yourself that not having sleep and working around the clock right before trial isn't going to help you. Making sure you have food and snacks that just keeps your blood sugar levels even, and taking breaks if you need them during the trial is fine. So as you do that, that will also help everyone else. So finally, the last knowledge that I wanted to impart upon all of you comes from my experience dealing with emerging technology litigation. And we've seen this repeatedly in some of the other jurisdictions' case laws, that when the judge is uncomfortable with what's being presented and it's a new and novel idea, they don't want to make a decision. And so your job is to go back to the basics and show the court that this isn't new and novel with respect to what they need to decide. This is based on long-standing law, and the principles that are new and emerging are for you and your expert to explain. And so you want to consider how you can easily explain that to the court, whether it's through having a little pretrial conference where you can provide them with a primer, with obviously on the agreement of opposing counsel, whether you show certain information or evidence ahead of time before it's live with a witness, so that again, the judge has time to review it. And again, prepare for all of this to go wrong, like I mentioned, and make sure that you just have a backup plan. And other than that, that concludes my part of preparing for trial, and hopefully that will help you with your checklist going forward in your practice.
Thanks, Erica. That was great. It's really helpful to see how pretrial preparation is essentially starting from the very beginning of the file. So that was really useful. Before we move on to opening statements, I'm just going to ask Arif if he has anything to add, and then Amandeep as well. Arif, do you have anything to add to Erica's thoughts?
I wanted to build off of Erica's kind of the early meetings and the kind of claim discussions and things like that. I think one of my mentors told me, and I think it's fundamental, is to never trust your client. So really need to, at that early stage, to test the evidence, test their case, and test things. And an expert is an excellent way to do that. I do practice, I guess, a lot of construction law the last 2-3 years, and having a good expert help develop your case is invaluable. So everything Erica said on that point is very useful and on point.
Perfect. Thanks, Arif. Amandeep, do you have anything to add on pretrial steps?
I just echo what Preeti said. Try to engage in the file as early as possible. When I was younger, it was amazing how I wouldn't know the file as well as I would until I started preparing for trial. And I always wish, well, if I knew this back 2 years earlier, I could have approached it differently. It takes time, and hopefully the client's willing to invest, but the earlier you can engage in the file and the documents, don't wait till trial prep. If you can do it earlier, you're going to be much more ahead of the game in regards to not only for trial, but maybe reaching a settlement or advocating for a settlement for your client before you get to that point, because sometimes it's too late at that point.
Great. Thanks so much. Arif, over to you for opening statements.
Great. Thanks, Geeta. I'm just going to share my slide deck. All right. I think everyone can see that. Perfect. Okay, thanks for joining in, everyone. I'm going to be addressing opening statements. I think it's a worthy topic on its own because it's such a critical juncture before you kind of advance into your trial or your hearing or what have you. So what I'm going to do is every opening statement is kind of unique, and I don't know that there is a set formula. I approach each statement differently depending on the case. But what I want to do is kind of go over what I think are certain goals you should have in your opening statement. The opening statement in my mind is so important because it is your first opportunity to speak to the decision maker directly. She's read your pleadings, perhaps not much else when she steps into the courtroom or the hearing room, but it is your first time to speak with them directly, and it is a chance to really elevate, personalize your case beyond what's kind of in the pleadings, which sometimes can be dry. It is your best opportunity to convince the decision maker as to why your client should win. And I think that's important. There has to be some really just reason, I think, or perhaps even a technical reason as to why your client should win. And it's a good chance to express that. Some basics that you should do. You should introduce the parties. You should introduce who the critical witnesses are going to be during the course of the hearing. And you should introduce the experts. And you should give some sort of forecasting of what evidence that each of them will present. A lot of people will talk about trying to make your client sympathetic during the opening statement, and I think that is a good goal. But I think you have to take a step back and always consider whether or not your client actually is sympathetic. Sometimes clients are not sympathetic. Sometimes you have to rely on some very technical arguments or the status of the law, and I think you have to consider at this point how to either make your client sympathetic or perhaps make your case sympathetic and or just. You can't always make your client sympathetic, and you just have to kind of deal with that at times. I remember doing an opening statement once, which got some traction with the judge, but within probably an hour or two of her direct, it was very clear the judge was not liking my client, and that day, in my mind, sunk the entire trial. And it was something I wish I'd probably dealt with a little bit better, in that my client was not sympathetic. She was a lawyer. I think the claim was probably a good claim, but it wasn't sympathetic, and that kind of affected the rest of the proceeding. So think about that, and think about how to make your case just, I guess, if the client is not sympathetic. So during the opening, it's fairly common to set out the facts that you expect will come out during trial, and so you'll say that as we'll hear from the plaintiff, the car went through a red light or whatever it may be. But at this point in the hearing, typically your view is that the evidence will show, because at that point in the typical format of a hearing, there's no evidence yet. There might be some agreed facts, and you can certainly say that, but generally at this point, you're not entirely sure what will come out, so the evidence will show. And as I spoke to, give an understanding of which witness will speak to what facts or what part of the case. It's important for the judge or the decision maker to keep track of it at the time. One thing I think that's critically important is to not overstate the facts here. You will be judged against what facts you say during the opening statement will come out during the hearing. Me as opposing counsel, if you don't set the bar, if you don't meet the bar that you set in your opening statement, I will come back and remind the judge that Ms. So-and-so said the evidence would show that the light was yellow or what have you, and she's failed to do that. I will make those sorts of comments. My friends alleged fraud at the beginning of this hearing, but they've not been able to prove that, and that sort of things. Don't overstate. It will come back to bite you. Be fair to the facts and be fair to the evidence. So just be careful in that regard. I think that's something that young lawyers, myself included, were prone to as well. Definitely put your best foot forward, but make sure it's reasonable. One of the things that I think that's important about the opening statement is to set the context for the hearing. In the context, in a motor vehicle accident or something like that, it could be describing the intersection or describing traffic or whatever incidents that day. For a large construction project, it could be setting out, the history of the project, what the risks were, what the economy was like during that period of time, things like that. You have to make the circumstances tangible for the decision maker. And that, I take that back to something I referenced earlier. This is your first time that you can speak with the decision maker. And it is the most opportune time to give them that context and that background that they need, because while you've been living this file for, as Erica mentioned, probably years leading up to the hearing, they've probably just picked it up a short while ago. And so the more you can do to help them shape and understand the case from your client's perspective, the better during opening statements. And the other point I should mention that when you do provide adequate context at this point, you will help the decision maker appreciate the evidence that's to come. And that's important as well. Again, you've lived this file for years. You know why the evidence is important. During closing arguments, you'll obviously get to address that. But if you frame your context and you frame the legal framework, and we'll get to that, if you frame that well in the opening statement, the decision maker will have a better idea of what the evidence means, what the implications of the evidence are as it comes out. And it's a little bit more organic that way, because you always want to leave the decision maker with the impression that they're reaching the conclusion. Those are the ones that will stick. The decision maker sees A plus B equals C. That will stick better than if you were simply arguing, C. It's a little bit more organic, and it seems natural, and it's effective. One of the, I think, very important purposes of an opening statement is to focus the issues and to provide that legal framework. As the decision maker receives evidence, you want them to appreciate how that fits into a legal test. You want them to think about who carries the burdens, and you want to tell them who carries the burden. Who has to prove? I just finished a hearing last week. Who has to prove that the investigation was inadequate? Who bears that burden? What do they have to prove to establish that it was inadequate? You want to frame the issues so that the decision maker is thinking about them actively during the course of the hearing. So one thing I like to do, and I do this pretty much for every hearing, depending on the size of the hearing, I will either do a brief of law, or I will present maybe a case or two that provides kind of the legal framework or the test. And so when I say brief of law, I don't mean argument, because I think it's entirely improper to make argument at the opening statements. What you want to do is to list certain principles of law that are applicable to this case. So, for example, in order to establish damages, you have to show causation between the breach and the damages suffered. And Supreme Court, there's a Supreme Court authority on that point. Referencing the case the hearing I did last week, to show the adequacy of an investigation, to show the inadequacy of the investigation, the burden is on the appellant. And here's a case that makes that point. So I usually like to present the points of law that are important to my case, and just provide a 1 or 2 sentence kind of summary, or perhaps the legal test, and one significant authority for each point. And I do it in a way, I like to leave a bit of space between point 1 and point 2, so that if the decision maker wants to, they can use this as kind of their notebook and kind of make notes as we go along. And I do that pre-trial. You have to be careful about it again, so that you don't get into argument, so that it's something that's acceptable during opening statements. Another aspect of focusing the issues that I think is actually quite critical is to actually narrow in on the disputes between the parties. I think that's often gets missed, and I think most decision makers are looking for help as to what do I actually need to decide to resolve this dispute, and if I make decision A, what is the consequence of that to the rest of the hearing. So for example, in my file last week, if one of the key issues was whether the investigator should have interviewed every proposed witness by the claimant, and the investigator didn't. And one of the issues was, well, if I, the judge, find that the investigator ought to have interviewed every single person, does that necessarily mean that that the investigation should be set aside? And so those are things you can frame and set out at the beginning, so that the decision maker knows what they have to decide and what the consequences of those decisions will be. And I think that's useful, because I think every decision maker generally is looking for as much assistance as you can provide to them. Yeah, Erica references as well, theory of the case. It's important for every case. It informs how you present your evidence, what experts you'll require, also, your legal positions, all of that. And one place to explain it to the decision maker is the opening statement. Once you've set out the appropriate background, who are the parties, what is the context, then you can begin to lay out your theory of the case. You can set out your position on the legal framework or on the law. I think you're best to foreshadow arguments that you're going to make later, not get into arguments at this point. But in my mind, why the theory of the case is important at this stage, you've started a trial, you've started a hearing. You want your position to be plausible, you want it to be believable, and most of all, you want it to be compelling. And that can mean setting out a theory that makes your version of the facts more reasonable or sound more credible. It can mean setting out your position with respect to the law in a way that is the most rational outcome when you apply the law. So the theory is important for all of those reasons. So if your theory makes sense, you're likely, the decision maker is likely to, decide or rule on the facts of the law in a way that favors your client. I think every decision maker and all of us really rely on our personal experiences, our common experiences, and there are some things that just make more sense than others. And if you're able to present a theory that at some visceral level makes more sense, you might get some more traction with your evidence and your legal arguments. Forceful and positive. So an opening statement, I'm not sure if forceful is quite the right word, but it needs to be well presented, and I think your positions should be laid out in a positive manner. And what I mean by that are things like, the plaintiff should be paid for their time and materials, rather than saying, rather than presenting it as the defendant refuses to pay for work. A positive way to put that is my client deserves to be paid for the time and effort. Going back to my hearing from last week, my position was that the investigation was thorough and complete. That is a positive way of presenting that, because the legal standard is whether an investigation was adequate and satisfactory. Well, adequate and satisfactory is not really compelling. So my take on that was that the investigation was thorough and complete. For reasons I've read about and I've seen presentations on that, I think people in the human mind seem to accept positive statements better than negative statements. So that's why I say that. Now we're going to get into some controversial ground. Your opening statement can be a place for anticipating and refuting the other side's defenses or positions or what have you. This is kind of controversial. Some people don't like to do this. Some people prefer to wait to hear the other side's argument before responding to it. I'm kind of of a mixed mind as far as that goes. I think it is worthwhile to refute counter arguments at this stage, because I think it is a time where you can kind of control that messaging, control that thinking, and frame that issue in a way that is advantageous to your client. So I don't shy away from this, but I am careful that I don't go too far into it. You don't want to go so deep into this that you reveal the entirety of what your responses are to the other side's arguments. My mentor in the office, he calls it like opening the kimono. There's only so much you want to show at this stage. You want to save some for your arguments later, but I think it is a good time to at least plant some doubt in the decision maker's mind and have that doubt present as they receive the evidence throughout the course of the case. Along that lines, and something I'm more in favor of, but potentially controversial as well, is to volunteer your weaknesses. Let the decision maker know during the opening statement what the weaknesses of your case are and how you might address them. I think it's actually useful to do it at this point because it allows you to control the formulation, the messaging. It takes kind of the sting of it away. It's not going to be some surprise that comes out during the course of the evidence. It lets you try to deal with it at this front end, which can be useful. So it's not just some sort of surprise that pops up for the decision maker at least. But again, at the same time, a word of caution, avoid shadow boxing. I mean, avoid trying to respond to things that your opponent may or may not raise. So it's a bit of a fine line, and that's why it's controversial. You know, some counsel think it is better to sit back and wait and see what the other side presents and then argue against it. My preference, cautiously, is to plant some doubt regarding the other side's defenses and to deal with the weaknesses in your case at the front end, rather than having it appear out of nowhere during argument. And I think the last thing I wanted to talk about was the relief sought. Sometimes missed during opening statements, but you want to take your position and you want to describe the relief that you're actually seeking, whether it's damages, some sort of specific performance, what have you. You want to discuss it at the opening statement, and you want to connect the damages that you're seeking to the claims that you're advancing, so that that is understood from the get-go. It's also important that at this point you've considered thoroughly what relief you're seeking in the context of your legal framework. You want to make sure that the relief you're seeking is available to you. And you know, when you're talking monetary damages, maybe that's not that big of a deal, because it might be very straightforward. But you know, you do want to think about whether restitution is available versus ordinary damages. Are you seeking compensation? Are you seeking money back? I do a fair amount of fraud work. Do I want a constructive trust over certain property? Am I entitled to that over this type of property? All those sorts of things you want to have considered so that you can explain to the judge exactly what you're looking for, and that they know at that point what you're seeking. And when required, you want to provide the authority for that relief. If it's legislative, point to the legislation. You know, that could be something like the Fraudulent Preference Act in Alberta, the Statute of Elizabeth. You know, if we're talking about fraud cases, you want to point them to the authority so that they know that they have the power and the ability to do it. And going back to kind of my earlier comments, if you're providing a brief of law at the beginning, that's also a good place to point that out. Here's your authority for imposing a constructive trust. It's found at section whatever legislation, and here's the test for it. Decision makers generally like to know what their authority is, especially when it is outside of, you know, kind of the ordinary kind of monetary relief. So I wanted to keep this very short and simple, and take questions if there are questions. And so I think I've kept it to about 20 minutes.
Perfect. Thanks, Arif. That was great. Right on time. Very useful, in both in terms of the substance, preparing an opening statement, as well as the delivery, and how you can craft your use of language. Just as we did last time, we don't have any questions, but I actually had a question. Perhaps maybe all three of you can give your thoughts, but if you briefly touched on how, you know, what you would do if you were opposing counsel when listening to the opening statement of, you know, by the other side. Do you have any thoughts on how to do that? You know, what you might do when listening to someone making an opening statement, and how you can then potentially respond or use that in throughout the trial, to whether it's saying that they haven't made out the case that they're trying to make, or they haven't successfully defended.
Yeah, I think two things I like to do for larger hearings, especially. For larger hearings, you'll get a real-time transcript, and I'll do that with an opening. And two things I'll look for any admissions that the other side has made during the opening. I think that's useful. And then you can say at the end, you know, my friend made an admission that this happened on a Tuesday instead of a Wednesday, whatever. And then, like you said, I like to keep kind of a checklist of these are the things that they said they would do. Here's how they failed to prove this, or they failed to meet the standard. So yeah, I like to have that transcript and kind of pick it apart as we get to closing arguments.
Great, that's really helpful. Amandeep, do you have any thoughts on opening statements?
Yeah, I would add, I'm a big proponent of, I anticipate my friend will say, if I'm going first or if I'm going second, you heard the plaintiff's counsel say X, Y, and Z, and then say to the judge, well, unfortunately, that's going to not be made out of the facts because of X, Y, and Z. Now, you don't want to overstate. That's the worst thing. I'm a big fan of saying, I told you this is my opening, and then in the closing saying, I proved it, and here's why. So I do listen to what the other counsel says, and then I try to address it in my opening saying, I understand they're going to argue this or show this. The problem with that is X, Y, and Z. I'm going to show you the problem is X, Y, and Z. So I'm sort of big with throwing a salvo back at the other side just to let them know or get them thinking about where I'm going. I may have other directions. I don't want to show a lot, but just to get them thinking.
Great, thanks. Erica, do you have any thoughts?
Yeah, no, that was great. I think those are all amazing things to consider. I think what stuck out with me is that you really need to be able to think on your feet at the end of the day. And that's why the preparedness leading up to trial is so important, so that you can just really focus on that. And I do agree with both Amandeep and Arif that I think you do need to anticipate and respond depending on if you're first or second to the other side. Otherwise, you're sort of just delivering a speech. And so that's where the advocacy comes in, to be able to say something in advance in the most effective way, or to respond in the most effective way. And so without having that preparedness, you're not there. Arif actually touched on something that twigged me, though, that you sometimes forget about the relief sought. That's another thing to consider when you're preparing for trial. And the other thing when you're preparing for trial that I actually sometimes forget is to prepare your arguments for cost. So I think that's another thing that you should be prepared to address, because oftentimes the judge will say, you can come back, but there's been cases where the judge has said to me, no, I want to hear from you right now about costs and get this over and done with. So I think that was just something that reminded me to remind you guys about.
Thanks, Erica. That's great. Amandeep, over to you for direct examination.
Okay. Let's see. Can you guys see my share screen?
I can. You're not quite in the, it's not in the full PowerPoint view, but I can see.
I'm trying to figure out how to make it in the full PowerPoint view.
I think that there's a button at the bottom left that sometimes allows you to.
I unfortunately cannot see that.
If
Nope.
not, why don't you just, if you go back to, yeah, just go like this. We can see your slides.
You can see it?
I can.
Okay, so I guess I'll start.
Perfect.
Perfect, thank you. Okay, so I'm here to talk about direct examinations, and Arif sort of touched on it. Another way to look at, I look at openings are sort of like a movie trailer. You're telling your audience, which is either your judge or a judge and jury, what the case is about, what's your story, what's your narrative, and you're providing a preview of what you're going to prove or what evidence you're going to put forward to establish your claim or your defense. And so your direct examination should tie into your opening. It should reflect or mirror your opening, or at the very least be consistent with the narrative or story in your opening. And oftentimes, there may be occasions, where you prove your case through cross-examinations, but at the very least, your direct of your witnesses should be consistent with the story, the narrative you've outlined in your opening. So I'm here to give some thoughts about things you should keep in mind in regards to how to approach a direct examination. The first thing I have up is trial advocacy is about persuasion. Your goal is to convince the trier of fact, whether that be the judge and or the jury. You as the lawyer are the storyteller. You're not trying to convince your client or the witnesses. You're trying to convince or get the judge and or jury on your side, and you're the one telling the story through the witnesses. It's not the client's job, it's not the witness's job, it's your job. The other thing to be cognizant is that it's a three-party relationship when you're in trial. Oftentimes lawyers get focused on just the witness-lawyer interaction, but there's a judge and jury there. So your job as the lawyer is to get the story out through the witnesses, through clear, concise questions, simple questions, understandable, and get that evidence out in a digestible format through the witnesses. But you're getting that evidence out for the purposes of that judge and or jury understanding the evidence in a reasonable, comprehensive, digestible format. So you have to realize that you're having a conversation, you're examining the witness, but there's an audience and they're the ones who are going to decide at the end of the day whether to buy what you're selling in regards to the case you're trying to advance forward. Witness selection is an important aspect, and I believe we've touched on it today. Who are your witnesses going to be in chief, in direct? You need to ask yourself some questions, like why are you calling them as a witness? Where does this witness fit into your story, in your narrative? What evidence do you need to get out of this witness? Can you get that evidence from other sources other than this witness, whether it's a request to admit, whether it's through cross-examination, whether it's another witness? How does this witness advance your case? Oftentimes there's a view among younger lawyers that the more witnesses you have, the more people you put forward, the more credible your case will present to the judge or jury. But you have to consider, is this witness going to harm me, or is this witness going to help me in my case? You may be able to call, you may want to call a witness to get a specific fact or piece of evidence out, but you have to consider what's going to happen to that witness on cross. Is opposing counsel going to be able to adduce more evidence favorable to their case than what you're able to get out of that witness for your purposes? Is this witness credible? Is this witness reliable? Is this witness going to undermine the evidence of my other witnesses, or undermine the credibility of the evidence I'm putting forward through the documents? So you really have to do a weighing of the pros and cons about, is the value I'm going to get from this witness, does it outweigh the potential risk or harm that this witness may lead to through cross-examination or through your direct examination? So you need to make a judgment call in that regard. I have up on the screen a slide that says pay attention to the parties. So things to keep in mind when you're examining in chief or in direct. And before we get to the type of questions you want to put forward, it seems simple, but look and listen to the witness or the witnesses. If you're not paying attention to the witnesses, then why should the judge? If you're not interested in what the witness is saying, then why should the judge? And it seems simple, but oftentimes you'll see a lawyer ask a question and then they're looking down at their notes or they're making notes. And so I think you need to show the judge and show or the jury that this witness is important. I'm paying attention to what they're saying. You should pay attention to what they're saying. You also need to pay attention because that witness, if you miss what the witness says, you may misrepresent the evidence going forward. If you miss what the witness says, you may misrepresent their evidence. You may ask questions which are inconsistent with their evidence, and therefore you're going to look foolish. You're going to look unprepared. Your witness is going to lose credibility, and you may lose credibility with the judge. And so to that end, you got to be careful about sticking to a script. I know a lot of lawyers like to write out their questions or sort of a roadmap of where they're going, but you need to be aware of what is going on in court, because sometimes no matter how much you prepare a witness, that witness may go off script. You know, witnesses are human. They're often nervous. They're unreliable. They're inexperienced. For many of them, it's their first time in court. They may say things you don't expect. They may say things in a way you don't like. The evidence may not come out the way you want it to come out. So you need to be attentive. If a witness says something unexpected, you have to decide, do I do a follow-up? Do I do a further line of questioning on what they've said? If the witness forgets something, to say something, excuse me, or doesn't provide the answer the way you want, do you need to reframe the question? Do you need to go back and clarify the question? Sometimes the witness may forget an answer or forget to answer a question the way you want. And therefore, if you have exhibits, you may want to anchor their questioning, your questioning, or their answer. You may want to support your client's evidence by going to the document, by going to an exhibit. You know, oftentimes witnesses may struggle giving an answer, but if you go to the document and you ask them about the document, it helps refresh their memory, it helps calm them down, and it makes the questions flow easier. Oftentimes, if you're asking a question about a document, an email, a contract, you need to go to the document because the witness will need that to understand what you're asking the question about. So take them to that email. If there's a specific paragraph in a contract you want them to discuss, take them to that paragraph. Let them read the paragraph and then answer the question about that paragraph. Another important thing is don't interrupt your witness. It's frustrating for the judge. It's frustrating for the witness. Allow them to finish their question. It sounds easy, but oftentimes lawyers in their minds are going on to the next question before their witness has finished with the previous question. And this is particularly challenging in Zoom because of technology. Ask your question, let the answer flow out, maybe pause a second or two to make sure that your witness is finished, and then move on. I also say here, look at the judge and or jury. The judge or jury has to absorb and understand the evidence. Also look at the judge in regards to how to pace and manage your direct. Is the judge paying attention? If not, wait. Sometimes a clerk will give the judge a note, or a judge will be looking at a document or looking at an exhibit. So you want to wait to see you got the judge's attention. The judge will tell you if you're moving too slowly. Is the judge taking notes? If the judge is taking notes, stop and slow down. I have a tendency to speak very fast. Oftentimes I'll get my cue from the judge as to whether I should move on to the next question if they're writing something down. You don't want to regret a situation where the judge is writing down an answer or your question and the answer, and you're moving on to perhaps the most important line of questioning, and the judge is not paying attention. If the judge is not paying attention, they're not hearing that evidence, they're not absorbing it, and you've lost that ability to really reaffirm that position or that line of questioning with that judge. Does the judge look confused or concerned about an answer? That may give you a cue about rephrasing, about clarifying the question asked. And if you're going to a document, if you're going to an exhibit, wait for the judge to get there. If it's important enough to put to the witness, then you got to wait for the judge to get there. Oftentimes judges like highlighting documents or making notes on it. So just wait for the judge. Use the judge as your cue. As I said, if you're going too slow, the judge will let you know and tell you to speed up. In regards to how to examine your witnesses, I have this direct versus leading question slide on the screen. I will get to this in a second. In regards to preparing your direct, a good way to organize this, and this has been touched upon, I believe, by Erica in the preparation for trial, is to create topics or headings in regards to how to structure your examination. It helps create a roadmap for you to simplify your examination. Oftentimes you may want to create a chart and say, okay, there are 5 topics or 5 areas or categories of concern in this case. What are the witnesses I'm going to call? What evidence do I need to get out to address that topic? Where's the source of that evidence going to come from? If it's a witness, okay, that's where that witness fits in. If it's a document, make sure you go to that document. So you're trying to understand what evidence are you going to try to get out for that category, through which witnesses, and through which documents. And for once you sort of organize your direct in regards to where you're going and how many topics you're going to cover and what witnesses you're going to use and what documents you're going to refer to, you now know the evidence you need. That will allow you now to go back and phrase and frame the questions you want, right? And the questions you're going to put forward to your witness, you want them to be simple language. You want to keep the questions short. Try to avoid compound questions. Try to limit the questions. I've been taught 1 fact per question. It will make your examination flow freer. It will provide you an opportunity to provide a better visual or image that you're trying to paint for the judge as to what the evidence presents as. Which leads me to the leading versus direct topic. No leading questions. Leading questions are generally questions which suggest or provide an answer to the witness. Those are not permitted in your direct or your examination in chief, except for limited circumstances. For example, introductory questions. When you're introducing a witness at the start of their examination to anchor or establish that witness, oftentimes you can ask leading questions about their background, their education, or their work experience. For example, Mr. Smith, you went to Concordia University, you graduated in 2009 and then went to law school at McGill. Afterwards, you started a job at X law firm. You're generally allowed to ask those questions. Furthermore, if the evidence is previously in the record, whether it's by way of a request to admit, whether it's by way of a witness, oftentimes you can use that previous evidence to anchor or provide the foundation of your next question. For example, you could say, earlier you had testified that the car was going 50 miles an hour on Highway 401. Which direction was the car driving on Highway 401? In that situation, you're anchoring your question based upon the previous evidence given. You shouldn't get too much pushback from counsel or the judge if the evidence is already in the record. But going back to leading questions, a good example of a leading question, or an example of a leading question, also say is, let's say you want to get out of your witness that he was on the phone on December 1st with a witness named Stephen, sitting in his office on the phone discussing a contract which is in dispute. You cannot put to your witness, on December 1st, why were you speaking with Stephen at 4 p.m. while you were sitting in your office? That's essentially the leading question. You're essentially giving evidence or suggesting an answer to the witness. You have to restrict yourself in direct to non-leading or direct questions, which are put on the screen. Who, what, where, when, why, or please describe. These questions are effective in informing or telegraphing to the witness and to the court what is the topic of your question and what evidence you want to get out of the witness from that question. So going back to our example about Steve and the 4 p.m. conversation, you may want to say, where were you at 4 p.m. on December 1st? And the witness will say, in my office. What were you doing? I was on the telephone. Who were you speaking with? I was speaking with Stephen. What were you speaking to Stephen about? About the contract. So the same evidence comes out. One is in a leading format, which will likely be objected to. One's in a direct format, which gets out the evidence in a clear, concise manner, one fact per question. That's a basic example of how to do a direct in that format. Another example, let's say you want to get into evidence that your client was driving to a party at someone's house, and he's driving in the morning, he was by himself, alone in the car, and it was raining. And let's say that's all relevant information. So there's a lot of facts you want to get in the record, that he was driving, he was going to a party, he was driving alone, and it was raining. You can't put to your witness, so on the morning of December 1st, you were driving by yourself in the rain to a house party. That's a leading question. Counsel will object. Where there's an objection, if it's upheld, you may be required to rephrase your question. You might not be allowed to. The judge may say, no, move on, it's unacceptable. You've now fed the evidence to the witness. Move forward. If the court does allow you to rephrase, which likely would happen, the consequence of asking a leading question is that the court may give little or no weight to the answer provided by the witness, because the evidence is not coming from the witness. The evidence is essentially coming from you. So in that situation, you want to break down the evidence you want to get out through the direct questions. What were you doing on the morning of December 1st? Where were you going? Who was driving? Who, if anyone, was in the car with you? Describe the weather conditions while you were driving, or what was the weather as you were driving? So through that line of questioning, you'll likely not get an objection, and you'll get the evidence you need. And once you've asked those questions and you get that evidence in, it can now provide the foundation, as I said, for future questions. For example, you advised me earlier that you're driving alone by yourself to the party on December 1st, and then you can proceed with your question. Please describe questions, or please explain questions. They are permitted as direct questions. Try to avoid them if you can. They're not specific. They're not broad. They're broad, excuse me. And you have to remember, you're the storyteller, not the witness. You control the story, and the witness is the mechanism or the vehicle by which the evidence or the story comes out. And you want the story to come out through your line of questioning. And you never want to relinquish control of your storytelling to your witness. But that's what happens, or the risk happens, when you ask a please describe or please explain question. And you don't want your witness to be the storytellers, because generally witnesses are not effective storytellers. As I've said earlier, they're usually inexperienced in trials. They're nervous. They're unfamiliar with the court process. They may give more evidence than you want. They may give evidence that you don't want, therefore potentially distracting, undermining, or sidetracking your story, your narrative, and therefore you want to avoid that situation. Now, these principles apply whether you're doing direct. These principles in regards to direct and leading questions, and sort of the approach to direct, also apply whether it's in direct or reply. So even in reply, you cannot ask leading questions. You still need to ask direct questions, addressing matters during cross. You're not rehashing your evidence in chief. From a defendant's perspective, so I've moved this forward. This applies whether you're the plaintiff's counsel or whether you're defendant's counsel. You're still trying to elicit evidence that fits into your case, your legal theory, your story, when it's your opportunity as defense counsel to do your direct of your witnesses, which usually follows after the plaintiffs have led their case. But also as your defendant, you have an opportunity. You have an opportunity to address or rehabilitate any harmful or hurtful evidence in the evidentiary record to date through the witnesses, or you have an opportunity to accentuate or emphasize or elaborate helpful evidence which has been put forward to date in the record. So you can't stick to your script. You have to adapt your line of questioning as to what has transpired. Also, when you're a defense counsel, you have to decide regarding witnesses, am I going to drop a witness? Am I going to add a witness? Oftentimes you may have the witnesses you know you're going to call, and then you may have some witnesses sitting on the bench that you may or may not call depending upon how the evidence evolves. And therefore you have to decide, or you may have to decide at some point, do I need to add a witness in my direct to substantiate my position in the matter moving forward? A few more items or a few more things I want to touch on, headings or transitions. Just like you want to sort of organize and structure in your preparation of your direct, I like to use headings or transitions while I'm doing my direct to signify to the judge or signify to the witness I'm moving on to another topic. I think this is particularly important where you have, for example, multiple meetings at issue, multiple documents or contracts at issue. You want to keep everything clear and concise. You don't want to confuse the witness. You don't want to confuse the judge. A simple way to do that is, okay, I want to now move on to X, Y, and Z, or I want to now talk about X, Y, and Z. So you're identifying to the court and to your witness, I'm ending this line of questioning or on this topic. I want to move on to talk about something else. It's a good organizing principle. Sometimes judges like it because they'll use that as an opportunity to say, can we take a lunch break now? Can we take a quick afternoon or morning break? So it's a good way to organize and structure your actual examination. I've also mentioned here, break down long answers to make them digestible for the trier of fact, going back to the one fact per question. Oftentimes clients or witnesses, may give you a lot more information or evidence in one answer than you've anticipated. Sometimes they've given you full answers. Sometimes they've given you partial answers. It's not unusual for them to give you an answer which sort of answers 10 questions. And this often comes from the please describe or please explain questions, or just their anxiousness to give evidence to what they believe is tell the truth. And sometimes witnesses provide more than they're asked. And therefore I believe it's important, if not necessary, to go back and break down that answer, to dissect it, to make it more digestible to the witness and also to the judge or the jury. It also allows you to expand or clarify the answer given. It allows you to emphasize the importance of the evidence given, especially if you don't want to get key evidence lost. So sometimes you get this long-winded answer and some of the evidence is important, but there's a really key piece of information in there that you don't want to get lost in the long answer that was given. So I like to go back. So I'll give you an example. So let's say you ask your witness what happened when they got to the house. And let's say your witness says, well, I stepped inside the house and there were all these people standing around and they were yelling and screaming. They were surrounding a body on the floor. There was blood and I saw a knife behind or beside the body. So there's a lot of information there. There's a lot of evidence that you want to sort of separate. So when I get an answer like that, what I usually would do is say, okay, let me take a step back. You said you got to the house, you stepped inside the house. Where did you enter? When you entered, what did you see? You said you saw all these people standing around yelling and screaming. Where were these people? How many people did you see standing around? Did you recognize any of them? Who did you recognize? You said people were yelling and screaming. Who was yelling and screaming? You said you saw a body. Did you recognize the body? Whose body was it? Where was that body? How was that body positioned on the floor? You say you saw blood. Whose blood? Or where was the blood appearing to come from? And where was that blood relative to that body? You said you saw a knife. Where was the knife? What color was the knife? What was the size of the knife? Was there anything on the knife? So hopefully I've been able to show you the difference between sort of a one question answer versus breaking it down. If you break it down, like I said, not only do you emphasize the evidence, but you paint a better picture for the judge. You provide a better visual to the judge as to imagining the witness walking in and seeing all these people standing around in the house and this body on the floor and there's blood and there's a knife. If that's the image you want to portray, I think it's more effective if you break it down that way as opposed to accepting that one question, one answer provided by your witness. the last thing I will address is address bad facts in direct. I'm a big proponent of addressing bad facts in direct, as opposed to waiting to be raised in cross. In most cases, you're going to trial because there are good and bad facts on both sides. It's not a slam dunk either way. Each side believes that they are in the right. So my preference is to address bad facts in examination chief, especially if I'm the plaintiff. It allows me to control the messaging or to present that bad fact in the way I can. It potentially blunts or dulls its impact or weight because you're addressing it before opposing counsel brings it up. And therefore it forces opposing counsel to wrestle back the view or the narrative on that bad fact. It also takes away the shock factor or the element of surprise for the judge or the jury if they hear it from you first before they hear it from opposing counsel. What you don't want is a situation where, you believe you presented a good case in chief, and then on cross, here comes the other lawyer, they ask this question, and the judge is like, oh, he didn't tell me about that. And now they're more interested in it versus, okay, I've heard about this, let's see where it goes from there. So I'm a big proponent of addressing bad facts in direct to the best extent that you can. So that's just a brief overview about how to, how to address a direct. Good luck next time you got to do a direct.
Thanks, Amandeep. That was great. Really interesting to see how this dovetails with Arif's presentation on not only what evidence you're trying to get out, but how you get that out, and the different ways to do that. Arif, do you have any thoughts on direct and Amandeep's presentation?
I guess I'd want to reinforce Amandeep's point to deal with your bad facts during direct. I think to be credible and to be convincing, you just have to deal with the warts on your case. And Amandeep is absolutely right. You are going to hearing because that perfect storm has arisen where facts might cut one way or the other way, and you just have to deal with it up front. And I'm a strong proponent of that.
Erica, what about you? Do you have any thoughts on direct?
No, those were all really good points. I think it's really hard to cram in all of the advice and tips that we probably have for all these topics. But one thing that I thought about was in the use of different types of evidence. So if you have photographs or videos and you're using that on direct with your witness, that you'll want to make sure that you actually prepare the witness with those documents in advance, because I think Amandeep made a great point that most of the times these witnesses are not great storytellers. So the more you can sort of prepare them for how things are going to unfold, the less unlikely you are for unexpected comments or information from them, which is definitely what you want to avoid.
Mm-hmm. Mm-hmm. Great. Well, I think we're right on time for today's session. Before we end, I just wanted to say thank you to Erica, Arif, and Amandeep for your time today. We know you're all busy people, so it's really useful to hear your thoughts on this. I also wanted to thank SABA, Toronto, and Calgary, Janani and Andy. We know how much time and energy goes into organizing these webinars and making sure everything goes smoothly. So thank you. We look forward to seeing you all at the next session, which I believe is cross-examination in 2 weeks today, I think. Same time, same place. So thanks, everyone, and stay safe.
Thanks.
Thanks.